Buenos días a todas, a todos. La Comisión Interamericana de Derechos Humanos les da la bienvenida a la presente audiencia pública sobre la situación de los derechos humanos de las personas detenidas en la Base Naval de Guantánamo. Me acompaña en la mesa la vicepresidenta primera Tracy Robinson, y la presente audiencia fue solicitada por el Centro por la Justicia y el Derecho Internacional, CEGIL, the Center for Constitutional Rights, Reprieve and Physicians for Human Rights, y como ustedes apreciarán, también se encuentra presente el expresidente de la comisión, el comisionado Felipe González, así como el comisionado Rodrigo Escobar, quien también es relator para personas privadas de la libertad. Como señalaba, le damos la bienvenida tanto a la digna representación de las organizaciones peticionarias como a la digna delegación del ilustre país de Estados Unidos de América. Tiene el uso de la palabra la representación de las organizaciones peticionarias por un espacio de 20 minutos.
Thank you, Mr. President. I would like to thank the Inter-American Commission for Human Rights for granting these hearings, and we also recognize the presence of the distinguished representatives of the United States government. My name is Francisco Quintana, and I appear today with my colleague Charles Abbott on behalf of the Center for Justice and International Law, CEGIL. The members of our delegations are Christine Husky from Physicians for Human Rights, Ramzi Kassem from City University of New York Immigration and Non-Citizen Rights Clinic, and Omar Farah from the Center for Constitutional Rights. Mr. President, honorable commissioners, the U.S. naval base at Guantanamo Bay, Cuba, nears its 12th year of operations and has become an entrenched part of the United States executive detention system. This honorable commission has actively monitored the human rights situation in Guantanamo since 2002. Through its petition system, precautionary measures, public hearings, press releases, and resolutions, and has repeatedly called on the United States to make individualized judicial determinations of the legal status of each detainee, safeguard their life and integrity, and honor the non-refoulement obligations, and of course, close down the detention center. On January 2009, President Obama issued an executive order setting a one-year deadline to close the detention facility. Now, more than 3 years after this missed deadline, the few concrete measures taken by this administration have indicated troubling normalization of the detention facility. In today's hearing, we specifically hope that the distinguished representatives of the United States will answer the following questions. Does the U.S. government remain committed to closing down Guantanamo? And if so, what specific measures is the state taking to carry out this process? This issue remains a pressing concern for the men detained at Guantanamo facing urgent and ongoing violations of their human rights, most of whom are now entering their second decade of indefinite detention without charge. Now, I will give the floor to Christine Husky from Physicians for Human Rights.
Honorable Commissioners, thank you for this opportunity. I am here, as mentioned, on behalf of Physicians for Human Rights to testify as to the negative psychological and physical consequences of indefinite detention. But I also testify based on my experience of having represented Guantanamo detainees since 2002 in the Rasul v. Bush case and many other cases, and having met with many of the men detained there. Let me start with a brief anecdote. In June of 2006, I went down to Guantanamo to visit my clients, and I met with one, and as I sat down, he slid a piece of paper across the table. It was his last will and testament. I was shocked. This is one of my most upbeat and optimistic clients. He had 4 young children. He was a member of the Kuwait national volleyball team. But he said to me he couldn't take it anymore. He couldn't take knowing whether he was going to be released or not, or ever see his family again. And so that act of desperation was 7 years ago. Fortunately for him, he was released soon after I met with him. That's not the case for Adnan Latif. Mr. Latif had been cleared several times by both the Bush and the Obama administrations, but he could not return home due to the moratorium placed on transfers to Yemen, which my colleague will discuss in more detail. Adnan was found dead in his cell just in September of last year. Officials ruled it a suicide. Adnan had reached such a level of hopelessness that he took his own life. The hopelessness and despair caused by indefinite detention is causing an extremely pressing and pervasive health crisis at Guantanamo, and one that deserves your utmost consideration. As you know, a person in indefinite detention is a person deprived of information about their very own fate. They are in custody without being informed of when, if ever, they will be released. Additionally, they don't know whether they will be charged with crimes, receive a trial or a hearing, or ever see their family again. And if they've been mistreated or abused, they don't know if such treatment will occur again. These attributes create a heightened degree of uncertainty over the elemental aspects of one's life. As clinical psychologist Jay Levin put it, indefinite detention places a person in a situation which is uncontrollable in any meaningful way, unpredictable in any constant way, and in which the individual is deprived of establishing an effective mode of confronting these conditions because of the apparent unaccountability. This constellation of properties causes severe and chronic states of stress, depression, anxiety, and dread, states that have persistent adverse consequences in healthy individuals, independent of other aspects or conditions of detention. In addition to these states of depression and anxiety and the others I've mentioned, the harmful psychological and physical effects of indefinite detention have been documented to include pathological levels of stress that damage the core physiological functions of the immune, cardiovascular, and central nervous system, as well as tissue and muscle. Compromise of the immune system exacerbates the metastatic spread of cancer and viral infections. In the cardiovascular system, plaque formation leads to plaque rupture. Chronic stress is a significant contributing factor to asthma, diabetes, and gastrointestinal disorders. Other effects include hypertension, depression and suicide, post-traumatic stress disorder, disassociation, schizophrenia, psychosis, and enduring personality changes. Some individuals even manifest physical symptoms of the psychological trauma they are suffering, such as breathing difficulties, physical pain, and skin disorders. Moreover, indefinite detention affects individuals beyond the detainee himself. It affects parents, spouses, children. They suffer the same feelings of uncertainty and unpredictability, leading to the physical and psychological effects that I've just mentioned. Adnan Latif left behind a toddler. He's now a young boy, a young teenager at 14, and for the last 10 years before his father died, he woke up every day wondering if that was the day his father was going to come home. Imagine the uncertainty that young boy was feeling. In cases where the individual has also experienced trauma beforehand, such as war, torture, or abuse, the physical and psychological effects of indefinite detention are exacerbated. In the case of Guantanamo detainees, there is no dispute that many were subject to torture and abuse while at Guantanamo. Thus, the psychological symptoms of indefinite detention, such as depression, anxiety, PTSD, cannot, I repeat, cannot be treated while at Guantanamo. This is because in order to treat these disorders, it is not enough to just dispense drugs. The acceptable standard of care requires a trusting therapeutic relationship between the individual and his therapist. And there's no evidence of any such relationships at Guantanamo, just the opposite. Dr. Vince Iacopino, Senior Medical Advisor to my organization, PHR, has examined numerous records and determined that in case after case, the detainee has made clear that he does not trust the treating psychologist because of past complicity in abuse, whether active or passive. In some cases, the inability to treat the psychological symptoms of indefinite detention is simply a continuation of the torture and abuse. In short, indefinite detention can cause lasting and severe psychological trauma and physical consequences that rise to the level of torture or cruel, inhuman, and degrading treatment. Thus, it's not surprising that there have been several suicides, though some of these are in dispute, such as in the cases before you, Mr. al-Zarahani and Mr. al-Salami. There have been hundreds of attempted suicides, hundreds of evidences of self-injury, hunger strikes, and my colleague, Mr. Ramzi Qasim, will talk about that more in detail. It is said the only way out of Guantanamo is in a coffin, either intentionally or naturally. But let me end here with this. The consequences of indefinite detention cannot be understated. They can cause severe and lasting physical and psychological damage that rise to the level of torture. At Guantanamo, the overriding hopelessness is presenting a health crisis that must be addressed Before Guantanamo becomes, in the words of Adnan Latif, and I quote you, a piece of hell that kills everything. Thank you very much for this opportunity.
Mr. President, honorable commissioners, my name is Ramzi Qasim. I'm a professor of law at the City University of New York. My students and I have been representing Guantanamo prisoners since 2005. Honorable Commission, the one thing that can make the psychological torture of indefinite imprisonment even worse is being handed a piece of paper that tells you that the U.S. government has cleared you for release, and then years later, you are still sitting in that prison with that piece of paper in hand. Two of the men that my students and I represent are in that unenviable position. Their names are Abdul Hadi Faraj, who is a Syrian national, and Shakir Amr, who is a Saudi national and the last remaining British resident at Guantanamo. But they are not alone. Out of the 166 prisoners who are left at Guantanamo, 86 have been cleared for release by the U.S. government's own processes. What this means is that every single agency in the U.S. government with a stake in national security affairs dispatched representatives, and that those representatives of the Department of Justice, Department of State, Department of Defense, Department of Homeland Security, the Director of National Intelligence's office, the Joint Chiefs of Staff, got together and decided that every single one of those 86 men should be released from Guantanamo, and yet they stay there today. So the grim reality at Guantanamo today is, as my colleague mentioned, that death or a conviction for a supposed war crime by a military commission are surer ways out of Guantanamo than the U.S. government's own processes that determine people cleared for release. What also compounds the psychological torture of indefinite imprisonment is knowing that your nationality, something that you cannot control, is part of what keeps you at Guantanamo. So out of the 166 prisoners who are there today, 95 are Yemeni nationals. And out of the 86 that I mentioned who are cleared for release and languish at Guantanamo years later, 56 are Yemeni nationals. If the U.S. government were serious about closing Guantanamo, one would think that the U.S. government would have had a plan to deal with this massive block of Yemenis at Guantanamo. However, the present reality is exactly the opposite. The U.S. government has imposed on itself unilaterally a so-called moratorium since January of 2010 that prohibits the transfer of any Yemenis from Guantanamo back home to Yemen. That, I would submit to this honorable commission, is the very definition of collective punishment based on nationality. Because the U.S. government suspects that two individuals engaged in nefarious conduct in Yemen, it has banned the return of all people from that country to Yemen, including the dozens who have been cleared for release by the U.S. government's own processes, effectively rescinding their clearances. So, honorable commissioners, the situation at Guantanamo today is dire. The U.S. government would have this honorable commission and the world at large believe that the prison at Guantanamo is a state-of-the-art, modern, model facility with content prisoners. But nothing could be farther from the truth. In the last 6 months alone, there has been a camp invasion in September where armed guards flooded a recreation area, beating up prisoners. There was a shooting incident at Guantanamo in January where a guard opened fire on a gathered group of prisoners and a prisoner was wounded in the neck. And on this very day, as we speak to you today, there is an ongoing mass hunger strike, which began on February 6th. I was actually at Guantanamo on that day, meeting with a client, and he informed me that the mass hunger strike began on that day in order to protest their ongoing imprisonment and the prison's continuing existence 11 years later. So every single prisoner at Guantanamo today is on hunger strike, excepting the sick and the elderly. That means it's 36 days and counting without food. One attorney reported just last week that he met with two of his clients last week at Guantanamo who had both lost 30 pounds. Two of his other clients had lost 40 pounds and were too weak to meet with him because of this ongoing hunger strike. 24 of the prisoners in the duration of the hunger strike have lost consciousness, some more than once. And despite all of this, we, the lawyers who represent the men at Guantanamo, have received no response from the Department of Justice or the Department of Defense to our complaint letters. So let me close with a few words about the client I mentioned earlier, Mr. Shakir Amr, because his case is illustrative. Again, he is the last remaining British resident at Guantanamo. He too is on hunger strike because he was cleared for release by the U.S. government's own processes years ago, and because the United Kingdom has officially and publicly demanded his repatriation so that he could be reunited with his spouse and children in London. This is not just any country, I would like to emphasize. It is the United States' oldest and most reliable ally. And that's important, because if even this man, who has been cleared for release and is being demanded by the United Kingdom, remains at Guantanamo today, then how come anyone How can anyone take the U.S. government's promises to close Guantanamo seriously? That fact alone should lead this honorable commission to question whether the U.S. government has any real plan at all to close the base or the political will to execute that plan. Thank you.
Good morning. My name is Omar Farah. I'm one of the staff attorneys at the Center for Constitutional Rights, which has represented Guantanamo prisoners essentially since the prison opened. I've been traveling to Guantanamo and representing men there for roughly 5 years. I must begin by thanking the Commission again for insisting on monitoring and scrutinizing the situation at Guantanamo. As you've heard from my colleagues, the situation is dire. Not long after our request for this hearing was filed, the office of Dan Freed, whose responsibility was to oversee the closure of Guantanamo, was dissolved. And so increasingly, it's only pressure from international bodies like this that are the best hope for a just resolution to Guantanamo. Our clients are coming to grips with a cold fact. They may well die at Guantanamo, not because the state is unable to transfer them, but because it's unwilling to do so. Each challenge or complexity that the state has confronted on Guantanamo policy has been met with retreat, acquiescence, and in many cases, outright excuses. And so I'd like to take one excuse off the table because it's one I think the Commission has heard before from the state, which is that the reason Guantanamo remains open is because of Congress and the NDAA. So let me clarify a little bit. We concede that the NDAA has complicated efforts to close Guantanamo, but it would be grossly misleading to say that the NDAA has prevented the state from releasing prisoners or affecting its plan to close Guantanamo. The transfer restrictions are difficult. For example, they would require the Secretary of Defense to personally certify that a receiving state had taken steps to ensure that a prisoner can never threaten the United States in the future, whatever threaten might mean in that context. And obviously no state can guarantee that a future event will or will not occur, but that was the point. The point was to discourage transfers from Guantanamo. And if that were the end of the story, it would be more difficult to fault the state. But the fact is, and the Commission should be absolutely clear about this, the NDAA grants the state all of the authority necessary to transfer prisoners. Specifically, Section 1028, which is the national security waiver, would allow the Secretary of State to transfer a prisoner for release if he were satisfied that a receiving state substantially mitigated the threats or the concerns that I just outlined. And to pause for a moment, we should consider what that means in practical terms. It means that if the Secretary of Defense were satisfied that the bilateral agreement between the state and receiving country addressed whatever purported security concerns were attendant to the release of a specific prisoner, then that he could certify that prisoner for release. We know from our collective experience that this is precisely the practice that the state has undertaken in all of its past transfers. And so in that respect, the NDAA is not requiring anything from the state that it wasn't doing already. If that were insufficient, the NDAA also permits the Secretary of Defense to certify a prisoner for release if it were in the national security interest to do so. That language should be familiar to anyone who's heard the state's complaint about the NDAA. In fact, the President himself said in his signing statement that, and I'm quoting here, the Section 1028 hinders the executive's ability to carry out its military, national security, and foreign relations activities. So if anything, the President's language is actually stronger than that already incorporated in the NDAA. As a result, the state's criticism of the NDAA in Congress rings hollow. And in fact, it's insulated the state, I think, from the criticism it deserves for its inaction on Guantanamo. Inaction, however, has consequences. They're not always seen in the case of Guantanamo, but they're there nonetheless. It has already pushed some prisoners to push the limits of what the mind and body can endure in order to register their protest. I represent Tariq Bauda, for example. He's a young Yemeni man who's been on an uninterrupted hunger strike since February 2007. He's force-fed daily by Guantanamo guard staff. In fact, as we speak, it's likely that he's being removed from his cell, strapped to a restraint chair, and a rubber tube is being inserted into his nose to pump a liquid dietary supplement into his stomach. Quite simply, Tariq says this is the only way that he has to communicate to those of us who have our freedom what it means to be unjustly detained, to be put in a cell for a decade without charge. It's his only way to, in fact, communicate the barbarism of such conduct. So I'd like to conclude by addressing the state directly. In light of the moral challenge that Tariq Bauda and the other prisoners at Guantanamo present, in light of the existential torment that indefinite detention creates for Guantanamo prisoners and the physical risks that it poses, in light of the fact that the state itself has conceded that more than half of the prisoners the state no longer has an interest in detaining through the clearances that my colleague just described, in light of the fact that 9 prisoners have died at Guantanamo in U.S. custody, And after 11 years, when is enough enough? We invite the state to begin its presentation by addressing the two threshold questions that we began this thematic hearing with, which are: one, does the state still intend to close Guantanamo? And if so, can the state offer any concrete steps that are currently underway to achieve that goal? Because at this stage, nothing else matters. Thank you.
Gracias a la representación de las organizaciones solicitantes por su presentación. Tiene el uso de la palabra la delegación del Estado. Les solicitaría y reiterar la bienvenida al representante permanente alterno, doctor Lawrence Convenier, si nos hiciera el favor en su oportunidad de presentar también la delegación.
Muchas gracias. Thank you very much, Mr. Chairman. Distinguished commissioners, secretariat colleagues, and members of the public, my name is Lawrence Gumbiner. I am the Deputy United States Permanent Representative to the Organization of American States, and I'm pleased to be with you here this morning. The United States supports the Inter-American Commission on Human Rights in its work to protect and promote human rights in this hemisphere, and we recognize and applaud the positive impact that the Commission has had on the laws and practices in many countries and the lives of innumerable individuals. We are here today at the invitation of the Commission to discuss U.S. government detention operations at the U.S. Naval Station in Guantanamo Bay. We hope to provide for the Commission's record, for the public, interest groups that have requested this hearing, and for the general public, information regarding the detention operations at Guantanamo. Specifically, we will speak to concerns raised by the requesting organizations and address misperceptions that have unfortunately become commonplace regarding human rights issues at Guantanamo. The United States takes very seriously its responsibility to provide for the safe and humane care of detainees at Guantanamo. Since 2002, the United States has continuously engaged with the Commission regarding our Guantanamo detention operations as part of our shared support for transparency and the rule of law in any activities that bear on a government's respect for human rights. I am joined by an interagency team of individuals whose work touches upon the issues that will be discussed today. With me are colleagues from the Department of State and Department of Defense. Our presentation today will be concise given the breadth of topics requested for discussion. However, we will endeavor to touch upon each of the 7 topics requested through the Commission for this hearing and attempt to clarify the actual policies and practices of the U.S. government at Guantanamo. Let me begin by introducing to my immediate left Mr. Michael Williams, who serves as Senior Advisor for Guantanamo Policy in the Office of the Legal Advisor at the U.S. Department of State. Mr. Williams.
Thank you, Larry, and thank you, Mr. President and distinguished commissioners, for this invitation. Let me begin by introducing my colleagues to my left. Tess Bridgman in the Office of the Legal Advisor, specifically the Office of Political and Military Affairs. Tara Jones from the Department of Defense in the Office of Rule of Law and Detainee Policy. And at the end, Natalia Semeka, also in the Office of the Legal Advisor for Human Rights and Refugee Affairs. To begin, because petitioners requested 2 specific questions be answered, as the rest of my presentation will address the 7 topics raised in the letter we received. Yes, the President has very recently reiterated his commitment to closing Guantanamo, and I hope that in my presentation you will hear some of the policies that we believe will implement those, or implement that political will. As an initial matter, I would like to emphasize that the United States is fully committed to ensuring that detainees are treated humanely and held in accordance with the law. All U.S. military detention operations conducted in connection with armed conflict, including at Guantanamo Bay, are carried out in accordance with international humanitarian law, including the Geneva Conventions, and all other applicable international and domestic laws. On his second full day in office, January 22, 2009, President Obama issued Executive Order 13491, ensuring lawful interrogations, which directed that individuals detained in any armed conflict shall in all circumstances be treated humanely, consistent with U.S. domestic law, treaty obligations, and U.S. policy, and shall not be subjected to violence to life and person, including murder of all kinds, mutilation, cruel treatment, and torture, nor to outrages upon personal dignity, including humiliating and degrading treatment, whenever such individuals are in the custody or under the effective control of an officer, employee, or other agent of the United States government, or detained within a facility owned, operated, or controlled by a department or agency of the United States. It further ordered that such individuals shall not be subjected to any interrogation technique or approach, or any treatment related to interrogation that is not authorized by and listed in Army Field Manual 222.3, which explicitly prohibits waterboarding and sexual or physical abuse. The order also required that all agencies of the U.S. government provide the International Committee of the Red Cross with notification of and timely access to any individual detained in any armed conflict in the custody or under the effective control of an officer, employee, or other agent of the United States government, or detained within a facility owned, operated, or controlled by a department or agency of the United States government, consistent with Department of Defense regulations and policies. Now, turning to the first topic that was raised in the letter we received from the Commission, the legislative restrictions currently in place on the transfer of most Guantanamo detainees. I would start by reaffirming what the requesters have acknowledged. This administration has publicly and formally stated its opposition to those restrictions. President Obama stated in signing the fiscal year 2013 National Defense Authorization Act, which contains those restrictions, that he continues to believe that operating the facility weakens our national security by wasting resources, damaging our relationships with key allies, and strengthening our enemies. He made clear that this administration will interpret these restrictions as consistent with existing and future determinations by the agencies of the executive responsible for detainee transfers. This refers to existing determinations by the 2009-2010 Executive Order Task Force, which often are referred to as approved for transfer subject to security measures. Turning to the second topic raised by the requesters in the letter, the U.S. government continues to stand by its decisions to designate certain detainees for transfer subject to appropriate security measures. We have transferred 71 of those individuals, including the resettlement of 40 detainees in third countries in cases where the U.S. government identified humane treatment or related concerns in the individual's country of origin. There are 56 individuals designated for transfer who remain at Guantanamo. Each potential transfer is individually assessed, as was the practice of the administration prior to the legislative restrictions, to examine whether appropriate security measures can be taken in the receiving country to mitigate the potential security threat the transferred individual may pose. To be clear, the U.S. government will continue to make transfer determinations on this individualized basis under existing law. In addition, it is important to note that in 2008, the Supreme Court held that all detainees at Guantanamo have a constitutional right to habeas corpus. That is, the right to challenge their military detention in U.S. federal court. As we have noted previously to the commissions, all detainees have access to counsel and to appropriate evidence in these federal court proceedings. Except where rarely required by compelling security interests, all of the evidence relied upon by the government to justify detention in these habeas proceedings is disclosed to the detainees' counsel, who have been granted security clearances to view the classified evidence. And the detainees may submit written statements and provide live testimony at their hearings via a video link. The United States has the burden in these cases to establish its legal authority to hold the detainees by a preponderance of the evidence. Many of the detainees at Guantanamo today have challenged their detention in these U.S. federal court proceedings. all of the detainees at Guantanamo who have prevailed in habeas proceedings under orders that are no longer subject to appeal have either been repatriated or resettled, transferred from Guantanamo, or have received offers of resettlement to be transferred. To date, 28 detainees have been ordered released by U.S. federal courts and transferred pursuant to those orders. The current legislative restrictions on Guantanamo detainee transfers do not apply to those detainees who are ordered released by U.S. courts. The third topic requested by the Commission, by the petitioners, is the issue of Yemeni nationals detained at Guantanamo, and specifically the suspension on transfers of detainees at Guantanamo to Yemen given current conditions there. That suspension was put in place following the attempted bombing of Northwest Airlines Flight 253 over Detroit, Michigan, a plot that originated with Al-Qaeda in the Arabian Peninsula in Yemen, and the circumstances underlying that suspension remain relevant today, although the suspension is to be evaluated on an annual basis under Executive Order 13567 of March 7, 2011. This suspension does not bar the transfer of Yemeni nationals from Guantanamo, but rather suspends transfers to Yemen. If a third country is identified as a possible resettlement option, but for any Yemeni national designated for transfer, the U.S. government would assess that transfer on an individualized basis, as it would for the transfer of non-Yemeni nationals also designated for transfer. The United States only detains individuals when that detention is lawful, and does not intend to hold any individual longer than necessary. For instance, in 2010, following the application of the suspension of transfers to Yemen, the U.S. government did transfer a Yemeni detainee from Guantanamo to Yemen after he was ordered released by a U.S. federal court pursuant to his petition for a writ of habeas corpus. The U.S. government is acutely aware that the majority of detainees at Guantanamo are Yemeni nationals, and recognizes the need to identify solutions for that population as part of our broader transfer efforts. On the fourth and sixth issues raised by requesters and through the Commission in the letter, specifically the psychological impacts on current detainees at Guantanamo and the sufficiency of medical care for those individuals, the detention facility's joint medical group providers administer care to all detainees at Guantanamo. This includes psychological services and care specific to a detainee's age group. Detainees are treated at dedicated medical facilities with expert medical staff. The medical facilities are equipped with 30 inpatient beds, a physical therapy area, an audiology booth, optometry exam room, dental treatment suites, an operating room, pharmacy, radiology, and central sterilization. Navy hospital corpsmen visit each cell block daily. Upon the request of any detainee for care, these corpsmen can refer them to primary care providers in this joint medical group. In addition to providing routine medical care, more serious medical conditions can be treated at the U.S. Naval Hospital at Guantanamo, which provides care to U.S. service members at the base. Additional specialists are available from outside the base to provide care at Guantanamo for medical needs that exceed the capabilities of the U.S. Naval Hospital at Guantanamo. Medical services are available to detainees around the clock, 7 days a week, and all detainees must provide informed consent for any procedures. The detainee healthcare ratio is 1 medical staff for every 2 detainees and 1 primary care provider for approximately 45 detainees. In addition to routine medical care, the Joint Medical Group provides tuberculosis screening conducted via quantiferon testing, which is the most accurate testing method available, age-appropriate colon cancer screening, 370 dental procedures annually, and more than 470 ancillary service appointments, which include things like physical therapy, radiology, and in addition, a range of specialty consultative care by medical specialists including cardiology, gastroenterology, neurology, radiology, urology, dermatology, audiology, orthopedics, ophthalmology, optometry, podiatry, and pulmonology. Specific to psychological treatment, the Joint Medical Group has a separate facility for behavioral health that includes outpatient and inpatient care. Services include preventive mental health screenings, comprehensive evaluation, individual and group counseling, medication management, and inpatient treatment. Mental health care is available for detainees as needed and upon request. The fifth issue raised by the requesters, which was embedded between the fourth and sixth in the letter, is the concern regarding deaths of detainees at Guantanamo. The U.S. recognizes that this is a very difficult issue and takes seriously its obligations with respect to detainees in our custody. When a Guantanamo detainee dies, the Department of Defense has protocols in place to conduct thorough, independent investigations into the cause and manner of death. As a matter of policy, the Naval Criminal Investigative Service conducts an investigation, and the commander of U.S. Southern Command also conducts an investigation. We implement lessons learned from these investigations to assist us in preventing future deaths. Finally, the requesters have raised the issue of criminal trials at Guantanamo. Alongside our federal courts, military commissions are an appropriate venue for trying violations of the laws of war. The U.S. government remains of the view that in our efforts to protect our national security, military commissions and federal courts can, depending on the circumstances of a specific prosecution, each provide tools that are both effective and legitimate. The Military Commissions Act of 2009 provides a number of protections in the military commissions process. Additional protections are reflected in the 2012 Manual for Military Commissions. For example, under the 2009 Act and the 2012 Manual, the accused has latitude in all cases in selecting defense counsel. Additionally, the proponent of hearsay evidence will have the burden of establishing its reliability, rather than the opponent proving its unreliability. In capital cases, the accused are provided counsel learned in applicable law relating to capital cases, and accused have the right to pretrial discovery. Importantly, the 2009 Act prohibits the admission of any statement obtained by the use of torture or by cruel, inhumane, or degrading treatment in military commissions proceedings, except against a person accused of torture or such treatment as evidence that the statement was made. Finally, the Act permits robust appellate review of any commission conviction by U.S. federal courts all the way to the U.S. Supreme Court. In conclusion, Mr. President and members of the Commission, while we have not had the opportunity to address the full breadth of the issues raised by the requesters in the time allotted here, and given some of what I heard at the table but didn't review in the letter, we hope that this information has helped the Commission to gain a more complete understanding of the current situation at Guantanamo. The United States will continue in its efforts, both with the Commission and more broadly, to be transparent in its detention operations at Guantanamo, including in explaining specific practices and policies and the situation of those individuals who are detained. Thank you for the opportunity to present this information here today, and we look forward to your questions.
Muchas gracias al Estado por su presentación, por la delegación. Tiene la palabra la vicepresidenta Tracy Robinson y relatora para los Estados Unidos.
Thank you, President, and I want to join in thanking the petitioners for continuing to ask the Commission to keep this on its agenda, which it's committed to do, and to the state for its response. I wanted to ask the state more specifically about what measures are being taken to close the prison. So you've said that there remains political will, but the petitioners have raised a concern about the closing of an office which was dedicated to facilitating this. And so the Commission would be very interested in getting more detailed information about what measures are now in place, given what you describe as a continuing commitment to closing the prison, and what initiatives are being undertaken. I also, in relation to the discussion about the health of the detainees at Guantanamo, listened carefully to the state's discussion about the very specific facilities which were available. But I understood from the petitioners that there was a concern not so much about facilities but about personnel, about not simply how many beds, what the ratio is, but also about who delivers that care, under what conditions. And I'm interested in understanding what are the ethical rules for the provision of that care, confidentiality, and to probably hear from the petitioners and the doctor in particular the specific concerns which existed in relation to detainees about the provision of health care facilities, particularly mental health care, by the personnel at Guantanamo Bay. I'll stop there for now, President.
Gracias, vicepresidenta. El comisionado Rodrigo Escobar, y relator para personas privadas de la libertad en esta comisión.
Buenos días. Quiero comenzar agradeciendo tanto a los peticionarios como a la delegación del Estado la información que nos han presentado sobre este tema tan sensible y que tiene muy preocupada a toda la comunidad internacional en materia de derechos humanos. Yo voy a hacer unas preguntas concretas, una en relación con la detención indefinida. Todos los estándares internacionales en materia de derechos humanos y en materia de debido proceso legal establecen que la detención preventiva es excepcional y solo puede llevarse a cabo por un término razonable. Más allá de ese término, se torna en una detención arbitraria. Y si a esa detención arbitraria se le suma que se trata de una detención indefinida porque el Estado no hace nada por definir la situación jurídica de los procesados, también genera un serio impacto en la salud psicológica de los prisioneros. Lo que acá nos han dicho los peticionarios no es algo nuevo, sino que está descrito en todos los tratados de psicología en relación con los prisioneros. La detención indefinida causa depresión, causa ansiedad, causa angustias y apatías muy grandes. Todo eso tiene su impacto en el sistema inmunológico de la persona y finalmente todo va a afectar también la salud física. A este tema pues no se refirió el Estado en su presentación, entonces me gustaría preguntar qué medidas se están adoptando para que realmente se supere este problema de la detención indefinida y como comporta una violación a derechos humanos cuando se trata de indefinida, ¿qué está haciendo el Estado frente a los responsables frente a estas detenciones indefinidas? Lo segundo que quiero preguntar es sobre el debido proceso. ¿Cuál es el debido proceso que se aplica a las personas que están recluidas en Guantánamo? Específicamente si se respeta principios básicos como el principio de legalidad o el principio del juez natural, y cuáles son los recursos que tienen las personas privadas de la libertad. Y una tercera pregunta a los peticionarios es en relación con la efectividad del recurso de habeas corpus. El Estado ha señalado que los prisioneros de Guantánamo sí tienen un recurso efectivo, que es el habeas corpus, que es frente a detenciones arbitrarias. Quisiera preguntar si ese recurso de habeas corpus realmente es un recurso efectivo. Muchas gracias. Como de pronto por la extensión del tema es posible que no se puedan responder adecuadamente las preguntas. En caso de que no se puedan responder, pues nos podrían allegar información al respecto.
Gracias, comisionado. El comisionado expresidente Felipe González.
Muchas gracias. Yo quisiera hacer una pregunta y luego un comentario. La pregunta se refiere a la huelga de hambre a la que se dieron referencia a los peticionarios. Según entendí, habían hecho algunos requerimientos a las autoridades para informarse al respecto, para tener mayor contacto con los detenidos y que no habían obtenido respuesta. Eso fue lo que entendí. Pediría que confirmen que es así y en caso de ser así, que por favor el Estado también responda en este sentido y nos proporcione información a la Comisión. Y lo segundo es que, como un comentario, es el hecho de que esta situación, que en esta oportunidad está planteada como una audiencia pública de seguimiento de la situación de las personas detenidas en Guantánamo, en realidad la Comisión la ha visto a través de otras vías también, incluyendo el mecanismo de las medidas cautelares. Existen medidas cautelares dictadas por la Comisión hace ya más de 10 años para las personas detenidas en Guantánamo que no se han implementado. O sea, no es solo una cuestión de un análisis general sobre la situación en Guantánamo, sino que hay medidas cautelares emitidas por la Comisión hace más de una década que no se han implementado. Ahora, estas medidas cautelares, me anticipo a los argumentos que se pueden emitir, estas medidas cautelares las emite la Comisión no solo en virtud de la Convención Americana sobre Derechos Humanos respecto a los estados parte en la Convención, sino respecto de todos los estados de la OEA en virtud de la Carta de la OEA y de otros instrumentos del sistema, como lo hizo respecto de estados latinoamericanos durante décadas antes de que los estados latinoamericanos ratificaran la Convención Americana sobre Derechos Humanos. De manera que no es solo una cuestión de información más o menos que se le pueda llegar a la Comisión, sino que hay una decisión adoptada por la Comisión hace mucho tiempo y que está pendiente de cumplimiento. Y esa decisión ha sido estudiada, discutida en numerosas audiencias. De acuerdo a los récords que tenemos, esta vendría siendo la 9ª audiencia pública que se realiza en la Comisión Interamericana sobre el tema de las personas detenidas en Guantánamo. Y en ese sentido, sería muy importante escuchar una respuesta del gobierno acerca de qué pasos concretos se van a adoptar para implementar las medidas cautelares. Gracias.
Gracias, expresidente. Ciertamente, reiterando el reconocimiento a ambas partes por sus respectivas presentaciones, lo han adelantado mis colegas, pero yo sí quisiera también que se profundizara en su oportunidad, si no ahora, en su oportunidad, con información complementaria que se sirvan a hacer llegar a la Comisión en cuanto a al remedio judicial efectivo, que ya lo anticipaba el comisionado Escobar, la información que tenga por una parte las organizaciones peticionarias y como también considera el Estado que lo ha estado atendiendo, el derecho correspondiente y por lo que se refiere a esa detención de personas en Guantánamo sin juicio previo, cuál sería el argumento jurídico bajo el cual el Estado consideraría válida esta detención y cómo lo consideraría compatible con el derecho internacional de los derechos humanos y el derecho a la libertad personal. Igualmente, como ya lo anticipaba la comisionada vicepresidenta, el expresidente, en cuanto a la importancia que pudieran hacer llegar el Estado información a la Comisión Interamericana sobre los pasos a corto y mediano plazo que tendrían programados para regularizar la situación de los detenidos en Guantánamo. La vicepresidenta Tracy Robinson.
My apologies, President. For the state, a quick question. I just wanted to be sure you would return to Yemen a Yemenis national successful on a habeas application, but not otherwise, not someone who has been certified as ready for transfer. So that's just an additional question, whether a Yemenis national could be transferred to Yemen who had been successful on habeas, but the 56 Yemenis nationals who are certified as ready for transfer, I guess in an administrative process, would otherwise never ever be able to go back to Yemen.
Gracias. Tendría 4 minutos cada una de las partes, en el entendido de que habrá oportunidad de hacer llegar información complementaria por escrito, atendiendo al tiempo fijado para esta audiencia.
If I can very, very quickly, and we'll supplement in writing on this particular question, but if I can quickly address the effective remedy question, because I think the state has made 2 broad points, one about the habeas corpus process and the other about the military commissions process, and I would respectfully submit to the Honorable Commission that both are deeply flawed and inadequate. On the habeas corpus front, just to give you a very quick illustration of the inadequacies, the access to evidence is very far from complete. Even we security-cleared lawyers do not have access to all of the evidence. Certainly our clients do not see the accusations against them because that evidence is classified secret, sometimes higher. Hearsay is freely admissible. The Court of Appeals has even created a presumption of accuracy to be accorded all government documents, and so they are presumed to be accurate, which is, unseen in any normal proceeding. Most importantly, federal courts do not possess the power to order release of a prisoner. They can only order the U.S. government to make its best efforts. And of course, international human rights law standards are clear on the unacceptability of indefinite administrative detention and the need for a full criminal process. That's the habeas process. The military commissions, I can tell you, having represented prisoners in front of many different iterations of the military commissioners, are not a functional system by a long shot. And let me leave it at that.
If I can just add, your question began with what concrete steps the state is taking to affect the closure of Guantanamo, and I'm not sure that I heard that over the course of the presentation. The state said that the NDAA, the president will interpret the NDAA in a way that's consistent with his ambition to close the prison. And you heard the state say that the Obama administration has released 71 prisoners, and while that's true, that number plunged to just 5 after the NDAA first included the transfer restrictions. And it's still the case that not a single prisoner has been released from Guantanamo under the authority that the NDAA includes. No prisoner has ever been certified for release under the NDAA, and the national security waiver has never been used to effect a transfer, which means that while the president may have the abstract commitment to act under the NDAA, in practical terms, he's never acted on it. And so we come back to the core question here, which is whether or not the state actually has the will to comply with this commission's calls to finally close Guantanamo. By all appearances, it's just simply not the case.
Could I just make a couple points here? Your Honorable Commissioners are completely correct in that all the beds in the world and the nice primary care providers do not negate the ongoing psychological toll of indefinite detention. And in this case, it's very important to remember The indefinite detention that they're asking for or justifying is under the laws of war. And in the states, United States mind, that war ends at the end of hostilities. Against who? Al-Qaeda and associated forces. Well, what does that mean? That's indefinite. That is the epitome of indefinite, right? So we can't negate the psychological toll of that. A second point I'd like to make is that, and we'll submit this in a submission, is that there has been evidence that the medical personnel in the past has ignored signs of torture and abuse. And that goes to your question, Commissioner Robinson, about the care that is being provided, the psychological care, who's providing it, and what is the trust and the ethical obligations and the confidentiality between the detainees and the people who are providing that psychological care. Thank you very much.
Gracias nuevamente por sus respuestas. Tiene uso la palabra la delegación del Estado.
Thank you, Mr. President, distinguished commissioners. Those are all very important questions, and you're correct. I can't answer them all, but I'll do my best to move swiftly as I can. Starting with Commissioner Robinson, I believe there was 3 questions there. I was Dan Fried's deputy, so the office rearrangement was a rearrangement. I still exist. My staff still exists. Dan Fried, Ambassador Dan Fried, was very important to our work, indeed essential to much of it, but we will continue to work through the Secretary of State and the other arms of the U.S. government to accomplish transfers. The legal status question, there is a U.S. law, the authorization for the use of military force. I don't believe this is a law you've not heard before. It is informed by the laws of war. That if and when a detainee challenges his detention in the context of this law, he is doing so to ask the courts to determine that his detention is not lawful under the AUMF, the authorization for the use of military force. I mentioned in my presentation that there are 28 detainees where this occurred, where there wasn't further appeal by the U.S. government against that decision by the court, and in all 28, to the extent that the U.S. government was able, we transferred those individuals. I mentioned that 3 did not, or still remain, I should say, at Guantanamo. They received offers for transfer and chose not to accept them. The other question was the specific measures to close Guantanamo. I think everyone understands that transfers are important to doing so. That's why we're here focused on those. The President's statement in the signing statement for the most recent law is very important in that regard because it is new. It wasn't in a prior iteration. I did mention it in my presentation, but I'll do so again. And again, understanding that Omar is correct that no transfers have been certified since the enactment of the first iteration of these certification requirements in the fiscal year 2011 National Defense Authorization Act. But the President said that we will, or his administration rather, will interpret the restrictions as consistent with existing and future determinations by the agency's executive responsible for detainee transfers. This includes the approved for transfer designations that have already been made. 26 of those are Yemeni nationals. There are 56 total of those determinations. The executive is going to stand by those and continue to do its very best to implement transfers under U.S. law. The specific case of Yemeni nationals, you asked if Yemeni nationals could be transferred under the current suspension other than through habeas. No, while the suspension is in effect, no transfers to Yemen will occur. The only one that did occur was through that habeas process. We do not see that suspension as permanent. We, in fact, very much hope to see conditions improve, not just in Yemen, but in any other country where there are security concerns, to implement transfers responsibly, to do so consistent with U.S. law, and to do so consistent with our desire to both protect national security, but also respect the interests of justice. The issue of psychological treatment, and I believe, Commissioner Robinson, you noted it as the staff, not the facilities, but the staff. Our medical staff is expert medical staff. I can't speak to the specific physician's oath or anything of that. I'm not a doctor. But the U.S. has no desire to hold detainees longer than necessary. So indefinite detention to us doesn't entirely ring true. The U.S. recognizes under international law that detainees are to be released and repatriated at the cessation of active hostilities, with the exception of those who are being tried for crimes or have been criminally convicted for their crimes. So what that means essentially is that we do not see this as indefinite, that there is a road to a conclusion. I believe the next questions were from Commissioner Escobar. The process, what recourse or remedies do the detainees have? What process do they have? This really is, again, a matter where we respect the U.S. federal courts, the process that is available through the U.S. federal courts, the decision by the U.S. Supreme Court to grant habeas rights to these detainees, and the availability of that recourse as a remedy to challenge detention and compel the executive through the courts to pursue their transfer out of detention. Commissioner Gonzalez, you mentioned the precautionary measures. I can't, unfortunately, provide a thorough response to that right now, but I will go back and look into those. And Mr. President, you mentioned what law, and this is, again, the authorization for the use of military force as informed by the laws of war, the laws of armed conflict. That's how the state views its detention authority.
Gracias nuevamente a la digna representación de las organizaciones solicitantes como a la digna delegación de los ilustres Estados Unidos de América por sus respectivas presentaciones y la información que se han servido a aportar a esta Comisión Interamericana de Derechos Humanos, que continuará monitoreando la situación de los derechos humanos de las personas detenidas en la Base Naval de Guantánamo a través de los diversos mecanismos a su alcance, y también agradecerá la información complementaria que se sirvan proporcionar quienes han participado. Muchas gracias.